guests and callers, and not necessarily those of this station, its staff, management, or sponsors.
Welcome to the Ask the Experts Show with local experts in the fields of legal, health, financial, and home improvement. Enjoy being educated in such topics as personal injury law, community association law, family law, bankruptcy law, along with health show topics like pain management, men's health, and dental implants. Now, sit back and enjoy today's Ask the Experts with host Steve-O.
Hey, good afternoon. We are live here on 1470 AM. This is the first Thursday of the month, so that means Kaye Bender Rembaum. And we had a couple calls last month that they were wondering if the show was taped. And yes, it was taped because these guys are very busy. But now we have one of the senior partners with us, Mr. Kaye.
Good afternoon, everybody. And last month, it was the 4th of July. So
That's true. That's true.
Everybody was busy that day.
Yes, but it's really good to have you back. And
thank you.
We put out on social media, send us your questions if you're a board member or management company. And we got a lot of people. They weren't board members. A lot of them are probably tenants. But that's okay, too, because this is your show. The name of the law firm is Kaye Bender Rembaum, and as we always start off the show, tell us about your practice.
Well, thank you, Steve. Kaye Bender Rembaum is a firm that focuses primarily on representation of community associations, condominiums, homeowner association, cooperatives, primarily, and we provide the representations to these associations through their boards of directors on the complete aspects of the operations of their communities, be it collection of unpaid assessments or reviewing their covenants for enforcement issues or interpretations of authority for the board, negotiating contracts and providing documentation for construction work or any other issues involved that the association is involved with, management agreements, cable agreements, the whole gamut. And then
there's a lot.
Dealing with enforcement issues and dealing with litigation issues. It's like operating a mini municipality, and boards are operating this business, as it were, which typically will have a fairly large budget, much larger than individuals have in their homes, and legal issues come up all the time. There are statutes in place that affect homeowner associations one way, condominium associations in a different way, and cooperatives very similar to the condominiums, but they're all different. So everything needs to be reviewed. There's case law that's been developed through the years that's been very significant in the operation of associations, and we're up on that. We also deal with the statutory changes. The legislature meets every year and adopts changes that affects what people do. This year, there weren't significant changes of any great magnitude, but there were little things. Next year, there's hopes for more significant things. There are already things in the pipeline being worked on. Mr. Bender is very actively involved in the legislative process and keeps his thumb on the pulse, as it were.
I wanted to tell you this because last month it was the 4th of July, and we actually got 2 callers. And both callers, they thought the show was live, both callers had somewhat of the same question, wanting to know about the website, if they could get in trouble if their website still isn't. 2 different callers asking the same question.
Well, the website requirement is a condominium-only requirement under current legislation, and it only involves associations of 150 units or more. The deadline to have it done has long since passed. To my knowledge, there hasn't been a concerted effort of enforcement on that issue, but that doesn't mean there couldn't be. So it is a good idea to come into compliance on the website issue as soon as possible.
Well, we put out word all the time. If you have a question, to write us. So we have a lot of questions today.
And also to call us.
Now, if you'd like to call in, the number here is 888-565-1470. Usually, in about the next 15 minutes, we start getting a lot of calls. So if you have a question, now's the best time to call. We have open lines, 888-565-1470. We'd love to hear from you. And you've got your schedule of what's going on. And so we're going to get to that. Nothing in Broward.
There is something in Broward, yes.
Good.
This month is obviously August. It's a time when many people are away, so there's less participation in the educational side, but we still, in Palm Beach Gardens, we have 3 classes that we are providing. The Condominium Association Board Member Certification class on Wednesday, August 14th. This one's going to be an afternoon one, 3 o'clock to 5:30. So that's a change from our normal 3 o'clock to 5:30 on Wednesday, August 14th, Palm Beach Gardens Condominium Board Certification class. Homeowner Board Certification class will be the following Wednesday, August 21st, also 3 o'clock to 5:30 p.m. And then on August 28th, the 2019 legal update. They call it 2019, but it's for laws that were passed in 2018. For managers, it's mandatory credits for their licenses, and there are 2 credits provided for that. Also 3 o'clock to 5:30 p.m. on August the 28th. On Tuesday, August 27th in Pompano Beach, we have elections, condominiums, homeowner associations, and cooperatives going through all of the requirements for those 3 types of communities at 6:30 p.m. for 1 hour. There is education credits involved in that as well, and that's in Pompano Beach. All of these are identified on our website at kbrlegal.com. Also, there are courses already scheduled into September. We have board certification courses in all 2 places. All 2 places. September 10th is condominium certification in Pompano Beach. September 11th is in Palm Beach Gardens. September 18th is the homeowner association in Palm Beach Gardens. September 24th in Pompano Beach. We'll talk about those more next month when we're back. And that's what we have on the calendar of upcoming classes.
And if you missed any of those, we always repeat them in the second half of the show. If you'd like to call here, if you have a question, if you're a board member, if you are a management company, or if you live in a condo or HOA, give us a call now. This is the great time to call in. It's 888-565-1470. 888-565-1470 if you have a question for Robert. Well, we're going to go into our questions. Some of these are back from last month. Joni from Boca wants to know, after annual meeting, the new directors went into a private room to elect officers. Don't they have to elect officers at an organizational meeting, and unit owners should have the right to be there?
Well, Joni, you are correct. When the board is electing officers, that would not be one of the areas that allows for them to go into a closed session out of the presence of owners that are entitled to attend and participate in the meeting. This applies to all 3 of the types of associations. They are allowed to use secret ballots, but that does not mean they leave the room. They can do that in writing, but they still would have to hold that portion of the meeting directly in front of the owners. Now, an organizational meeting quite often will occur immediately following the annual meeting, and no further notice is often required based upon what the governing documents will say. So you need to check that in your documents. So it sounds like they did have an organizational meeting, but it was improper to take that into a private setting.
Okay. Can a community association Can they tell you how many cars you're allowed to have?
Again, that's going to be something that depends on your document.
Do you see that, though?
We do see that. There's a lot of condominiums developed and homeowner associations as well that, since land is relatively scarce and developers often try and jam as much as they can into a small space, parking becomes sometimes a very difficult situation. Oftentimes we see a community that is developed that has a single parking space available for each particular dwelling unit, being a condominium or homeowner association, with a little bit of overflow guest parking, but quite often it isn't enough to accommodate everybody's needs, and that becomes a big problem that has very limited opportunities to fix because they only have the land that they have, and if they can't add on to it with creating parking spaces in maybe green areas, assuming owners would vote to do that, then they have to limit the amount of vehicles that can park in the community at any given time. We see that quite often. And they'll police it by providing you can only park if you've got a permit. Often there'll be an assigned spot for each of the units and then a second spot available on a first-come, first-served basis for a second car. But sometimes you have families with kids or multiple residents that all have vehicles, and you have 3, 4, 5 cars in a unit. Where are they going to go? That is a big problem in a great many communities that we see.
Does your firm get involved with the interview process of people who are going to be leasing a unit?
We don't get involved in the
what
actual
kind of questions
process.
should you ask?
We'll advise the board as to what they can and cannot do in the interview process. The advice that I generally give on this is face-to-face interviews are really something that we don't encourage because there's very little you can gain from that will be helpful to you in making your decision, but it does open you up to the possibility of a claim of discrimination if you deny the application for whatever reason. If you don't see the people, you don't know their background, you don't know their ethnicity, race, or whatever other issue, you're just going to be dealing with the application on its face, what they've given you, and what your background check tells you. The interview should be used more for a get acquainted once they've been approved. This is the board, these are the rules, here's the situations that you may be dealing with, what have you. So that's a better use of interviews.
That makes sense.
Yeah.
Okay. This is from Hal. Hal is from Broward. He says, my association request a full year of assessments before my tenant moves in to their community. They told me they don't have a credit score on me. Can they prevent this rental?
It is conceivable if the documents allow for the board to review and set up criteria for rentals that would be one of them to protect the financial integrity of the community as a whole. The statutes were changed in recent years to allow for associations to make demands on tenants for the rent when the owner becomes delinquent. And by virtue of that, the credit of the tenant became suddenly relevant. In the past, it didn't used to be because the landlord was obligated to pay assessments, and if they didn't get a good financial risk for their tenant, then that's their problem. But now the association has a vested reason to check into the background, and quite often a community will set up benchmark numbers as to minimum credit scores that will be acceptable, and that's generally enforceable, assuming they have the basic requirements in their documents to review and approve leases.
Okay. We're going to go to break. We're here with Robert Kaye. He's one of the senior partners with Kaye Bender Rembaum. Give everybody the phone number.
You can reach us at 1-800-974-0680, or you can send us an email at info@kbrlegal.com, and that would reach it to the proper people.
We're going to go to break. When we come back, we have more with Kaye Rembaum on Ask the Experts.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
We can talk more about that.
And we are back with, this is the Ask the Expert show. We are now on also from 3 to 4 on Thursdays on 740 a.m. It's one of the sister stations here, so we're on 3 to 4 on Thursdays and 5 to 6 here on 1470 a.m. If you'd like to call into the show, the number here is 888-565-1470. This is, without a doubt, our most popular show. We've been doing it for the last probably 3 years.
Maybe 4.
Probably, yeah, it could be 4. People really seem to enjoy calling in your answers. I love what you do because it involves so many people are involved in their association, and you do so many things outside. I mean, you do a lot. You give back to the community.
Well,
I guess that's the best
we
way.
try to do that. I mean, we do our courses, which are free, and we do provide some light refreshments to help get through it. And we also, as you know, have our traveling Ask the Attorneys,
which is amazing.
Which we start in November, then it goes through April, typically 1 or 2 a month in various locations around town. We also, on our website, we have some informational sections. Under resources, we have our legal morsels and our Rembaum's Association Roundup, which contain articles of topical interest to community associations on trends that are happening in the law that affect their operations and other interesting things. And that's also available at no charge to anyone who just finds us and clicks on it.
You do a lot of extra, even this show, you do a lot of things that you give back. I brought up about the parking before because Renee and I are moving to I guess it's an HOA. Mm-hmm. And I was surprised that they said you can only have 3 cars.
Well, at least they're giving you 3.
Yeah. Okay.
Is there garages or?
There's garages.
So is this in addition to your garage or just?
We're only allowed to have 3 cars there.
No matter what. And they have
so what if you
parking
have a
permits?
Party? Yeah.
Well, that's not someone who's living there. That's just visitors.
Okay.
So you can have visitors assuming there's guest parking available. And you can probably park on the streets during the party time, but other than that, there may be restrictions in place.
You're not surprised?
Not at all, no.
Okay. Yeah, but I was like, well, what if we had another car? We aren't allowed to buy one, and
you're allowed to buy one. You just can't keep it there.
Yeah, that's right. Yeah, remote your house.
Well, there's a country club nearby that has a large parking lot. Maybe they'd let you.
Okay, we got our first caller today.
Well, welcome.
You're going to have to help me with your name. Hello, caller?
Giacomo, yes. How are
Giacomo, okay.
Giacomo.
Yes.
Good afternoon.
Yes, perfect. Good afternoon, sir. How are you?
I'm well, and you?
Good, good. I just have a quick question. I want to take all your time. I was wondering, is there a state agency to whom one can report a board that's not doing their job in general to address this and maybe have some sort of recourse or any kind of feedback or
Are we talking about a condominium or an HOA?
HOA?
Okay, for HOA, the answer is no. There is no state agency that oversees homeowners associations. The Division of Condominium has limited jurisdiction over homeowners associations for the purposes of addressing disputes involving elections and recalls. But the things that you have identified, the board's not doing what they're supposed to do, or maybe in violation of the documents or the statutes.
Right.
There is
That's
no
my assertion.
there is no state agency that polices the homeowner associations like for condominiums. So what you'd be required to do is bring the issues you have to the courts. And before you can go to court, the statutes require there be pre-suit mediation, that you'd have to follow a specific statutory procedure. There's a letter in the statute itself that tells you basically what you have to say, and identify a mediator that would meet with the association and yourself ahead of time to go over issues that might be facing and try and resolve it without the need for actual litigation.
Okay, so we need a lawyer to file suit against the board to proceed?
You don't need a lawyer as an individual to file suit, but it is recommended because of the intricacies and difficulties that can go with litigation.
Okay, so that definitely legal help will be advisable, I would say.
And it would be a good idea to have the lawyer review the allegations and make sure that they are in fact something a court would deal with.
Right. So a little, pre-meeting with the lawyer. Okay, great. Another question I have, the violations committee is made up of 3 board members, and obviously they only share one view of things, and they do not show uniformity, no timeliness, many things go unresolved. Is that legal to have only board members on the violations committees?
Well, when you call it a violation committee, is this committee just identifying violations and sending letters? They're not fining anybody?
That's their function. Well, after, if you don't comply, there is a fining process, but the main thing is it's all board members. We have 5 board members, all voluntary board members.
No, quite often that's all an association can get to do that. But if it's imposing,
we had volunteers from the homeowners, and they categorically refused any intervention by anybody else.
They do have the power to do that, but for the fining part of it, if there's going to be a fine, the laws require there be a committee to hear the fine claim and make a decision whether or not to approve the fine that is made up of non-board members and no one who's affiliated with the board.
Okay, yeah, that I got was very clear, but the board members, the violation can only be made up of board members. That was my question there.
That is within their power on the board. It may not be the best thing to do, but the things you've identified are not things the board should be doing. They should be uniform, they should be timely, and they should be addressing everything.
Of course, that's the problems we're having. They're not doing all that, and we try to get on the violations committee to give them help. But that's basically it. I think you answered my question, sir. And,
how large is your community, Giacomo?
About 160.
And
houses.
Of the 160, what percentage do you think are unhappy with the board as you are?
Perhaps maybe I would say a third at the most.
Okay, so that makes it difficult because to remove them, you need a majority.
Exactly. There's a lot of rentals and some absentee law, and they have basically all the proxies tied up. So that we did try running, and it was not successful. They had pretty much of a hold of the proxies, absentee owners, and basically a lot of people happy with the status quo. That's what the problem is.
Well, you're not alone, if that's any consolation.
Yeah. Okay, well, that's great, but I wanted to just know about recourse and the makeup of the violations committee by the board members.
Yes.
But very good, sir. I
Thank you so
appreciate your
much.
time, and thanks for the show.
Hey, thanks for listening.
illuminating. Okay, thank you so much. Good
Bye-bye.
night.
We have an open line here at 888-565-1470. If you'd like to call Kaye Bender Rembaum, the phone number is
1-800-974-0680.
And you've got an incredible website. There is so much information on there. It's not just a bland website. It's like the morsels is incredible. Give everybody your website address.
Website is www.kbrlegal.com.
You know, it's so important that an association have a firm to represent them, because we've been doing this show 3 or 4 years now, and every week, every month, I get blown away. There's just so much that you have to know that you need a firm to represent you.
Right. Quite often, an owner-controlled association, owner-operated without the benefit of outside management, they try and keep their expenses low, so they don't hire experts, they don't hire attorneys, they don't necessarily
How do they do that?
Well, they stay out of trouble by basically not getting involved in a great many things, and when that happens, sometimes the communities get run down. People just do whatever they want. There's no order. There's no enforcement. And oftentimes the boards will come to the attorney after they have a problem instead of before they have a problem. And when you do that, you end up spending more on getting a resolution than if you had addressed it ahead of time with the attorney. It could have helped you head it off.
We are going to go to break right now. If you have a question for Robert, give us a call here at 888-565-1470. That's 888-565-1470. You can tell it's the summer. The calls are a little light. Usually we've got a board full of calls by now.
I'm still wearing my jacket, though.
This is the time to call in, 888-565-1470. We're going to go to break. We'll be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size, and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
You are listening to the Ask the Expert Show with host Steve-O. We will be right back with more experts in the field of legal, health, financial, and home improvement. Join us every Thursday from 5 to 6 p.m. Now, get ready for more Ask the Experts.
This is the first Thursday of the month. That means Kaye Bender Rembaum, our community association law firm. They've been with us now. It actually has been 4 years now. And we've actually added an FM station, 95.3, so you can reach us two ways, either AM or FM, or you can reach us on iHeart. On the app, you can listen to the show.
iHeart, huh?
And we know that our audience changes about every 15 to 30 minutes. So I've got to ask Robert to do this. It's hard because he's already done it once during the show, is just tell people a little bit about the firm.
Okay. Well, I don't think I said everything about the firm before.
Okay.
So there's more I can add. In addition to
Your
what
community association.
Community
law
association
firm.
is our focus. Among the 19 attorneys of the firm, 8 of us are board certified by the Florida Bar, which is a recent designation, just started last year, and I was among the first. In the state, I think there's maybe 150 in the whole state.
I mean, you can call yourself an expert.
An expert and a specialist, yes. In order to become board certified, you have to attain a certain level of expertise through experience, through education, through continuing legal education credits. Plus, you have to continue maintaining them in order to retain the designation. It's not a lifetime guarantee. You have to continue to earn it as the years go by. And so we have, as I say, 8 of us, and we have those in all 3 of our offices. We have in Pompano Beach, we have Palm Beach Gardens, we have Tampa. And all of our offices have board certifications. I believe if you want to go percentage of attorneys in a firm, we may have among the highest in the state of board certified community association attorneys. We do handle all aspects of legal issues that are addressed in operating a community association. There's very little that the board can bring us that we haven't seen. We've been continuously providing these services since 1992. So we're coming up on our 29th year, which is a long time to be doing the same type of representation.
This is mostly, not all, but this is mostly what your firm does.
Probably over 90%.
Yeah.
And what you gain from working with us is that experience, that while going to the attorney has a cost to it, when you go to an attorney that has the experience and the ability and the expertise to address your issues, it takes less time, and less time is translated into less expense. So we work in a manner that we consider to be as cost effective for our clients as possible, and to give them prompt and easily understood responses to whatever issues they have. We don't have automated answering. We have a live person who takes all incoming calls. We're very responsive to our clients. Legal opinions are generated within a matter of a day or two. Some response happens the same day that we receive any kind of an inquiry from our clients.
Customer service is very important.
Customer service is important. We understand that our clients come to the attorney not because they just are wondering about something or on a whim. It's because they have a real need, and their needs usually have a time limitation that they need to have it addressed. It's amazing to us as new clients come to us and the stories they tell about how they'll ask the attorney for something and they'll wait weeks and then into months and they don't get their response. And then when they do, they get something that they need somebody to translate for them because they can't understand it. And then they get a bill that's out of sight. So there are many people out there who claim to be community association attorneys, but a lot of them don't have the background and training that is necessary to provide such a expert type service.
And because we from time to time we get emails that people said, you are very easy to understand, that you don't talk over people's heads. I understand everything you're saying, but no, that's important.
That is
because,
important.
Again, you're dealing with board members,
lay people.
It's not a full-time job for them.
Right. We're not dealing with people who are necessarily expert in the field we are with the same level of understanding. So it's important to communicate what we know in a way that everyone can understand.
And you do that. Our phone number here, if you'd like to have a question for Robert, the phone number here is 888-565-1470. That's 888-565-1470. Please give us a call. We're going to go back to our, we get emails from people all across South Florida here. They have a question. They're either at work or in their car or something they don't want to call in. So we make it open so people can send us questions, and Robert and Michael don't have a problem answering them. This is from Loretta at Tamarack, and I actually remember her letter. She says she lives in an HOA. We lived under an expired covenants for 10 years. I might want to sell my condo. I don't want the board to come at me with monthly assessments. Someone told me there is a Marketing Record Title Act governing documents in HOAs that expire if they aren't preserved for 30 years.
Well, Loretta has the concepts down correctly. Although she uses the word condo, the Marketable Record Title Act generally does not apply to condominiums. There are exceptions, but in general terms, the Marketable Record Title Act is a Florida statute that dates back to the 60s. And that was, of course, before there was computerization of records, which makes the value of it today a little suspect, but with the lobbying that goes on in Tallahassee, particularly the real estate industry seems to be very passionate about retaining this in the statute. In our view, in a community association setting, it doesn't have the value that it used to. But under the Marketable Record Title Act, which is a very complicated statute, it basically provides that the covenants on real property will expire after 30 years from some difficult time to ascertain the starting point, a very technical, involved method to identify it. And this occurs if the original deeds that were given for the individual properties did not expressly provide for the OR book and page from the official records of the covenants, and it was not specifically identified on the plat for the entire community, then the covenant would expire after 30 years. And the statutes provide for methods to avoid that expiration. One would be to preserve them ahead of time before the 30 years happens, and that's done simply through a board meeting and having certain information take place at this board meeting and then documents recorded in the public record, which would preserve it for another 30 years. If the board was somehow negligent and did not preserve it timely,
She said
and
never
the time went,
revitalized.
then revitalization is an option, and that requires a vote of members within the community, and then documentation has to be set up to the Department of Economic Opportunity in Tallahassee to review. It's very technical in what's required to be presented to the owners and the vote, and then how it's presented to the department to be approved so that the documents can be revitalized. And for the time period between the expiration and the revitalization, assuming they get that, the documents are no longer enforceable or chargeable against the real property. And what that typically means, the biggest ramification of that, is that the association, which is not expired because it's a corporation and it has its articles and bylaws separate from the covenants, the association does not have the ability to file liens and foreclose against properties that don't pay their assessments. They can still operate, they can still assess, but they don't have a method of collecting on that assessment besides just a small
That's
claim
what you said.
action,
The
a
board has
personal
no
action.
right to ask for monthly assessment
Well, they do have
payments.
a right. They just have a problem in enforcing if somebody says no.
Okay.
But they still have a community to operate. So until such time as the board does revitalize those documents, should Loretta go to sell her property and the title company makes an estoppel request to find out what's due and owing on the property, there shouldn't be any assessments that are due and owing, but there could be, because the association could still be assessing, just
Right.
not filing a claim against the property. It's a personal obligation of the individual member. So it's complicated, and it can end up costing a lot of money. And quite often, it's best to pay the assessment and sell the property than to try and fight it.
This is really a unusual question. This is from Jean in Jupiter. She said, our condo association wants to add pickleball.
It's a growing and popular sport. You familiar?
Heard of it.
It's like ping
To their
pong.
tennis courts.
It's like tennis, only in a smaller scale, with different equipment.
You know about this.
Yes.
Says all they will be doing is
all the
adding
rage.
lines and lowering the net. Is that material alterations?
Well, under the law, a material alteration is fairly wide in what we would consider one. As we've mentioned on previous shows, the Division of Condominiums has decided that the change of color on the outside of your building is a material alteration. And why a material alteration is important is because the Condominium Act, and this only applies to condominiums, has a provision that says that there shall be no material alteration or substantial improvement to the real property, the common elements, except as provided in the Declaration of Condominium. And if the declaration is silent, then upon the vote of 75% of the members, which is a pretty high number. Most declarations of condominium will address it, at least the ones that were created after, say, 1976, 77. Some of the earlier ones are a little less artful the way they did that. But since that time, I'd say it's pretty much across the board. There'll be something about it in the documents, but quite often it's a high percentage, 75% or 2/3. Sometimes it's tied to the cost of the alteration that's being done. Sometimes it's based on the budget. So there are various things that can come into play. So you need to check your documents to see what the trigger is on this. You're taking a tennis court and you're turning it into another racket sport. So that's the argument that it's not a material alteration, but you're also changing the configurations of the lines on there. So there's a visible change. The net's different. This one could go either way.
Okay.
I think if you want to avoid any challenge and be completely safe, you get a vote. If you're a risk taker and you just want to roll the dice, there's certainly a viable reason that you would say this is not a material alteration based on the fact that
Not
it
like
is
painting a building.
right. But there's a little painting going on, but it's a racket sport for racket sport in the same spot. So that one is more in the gray area, but an interesting question.
Here's somebody, Rose from Oakland Park, want to know how many people should be on an HOA board. I don't even think we have a forum.
But she means quorum.
Yes.
A quorum, for those who aren't sure, is the amount necessary to have a valid meeting, and quite often it's a majority of those who sit on the board. But to answer the question, you'd have to look at your documents,
Okay.
number one, to see what the documents provide for and the number of board members. The default is 3 if there isn't anything, but there usually is something in there, and sometimes it's a range between 3 and 9, as determined either by a vote of the board or vote of the members. So you'd have to check the documents to see what that is. Start with your articles of incorporation and then go to your bylaws to see how many you should have. But if you don't have a quorum, let's say you have a 5-member board and you only have 2 board members, that's not a quorum. You need at least 3 to be able to conduct any business other than appointing another director so you can have a quorum. If you have only 2, the only thing they can legally do relative to the business of that corporation would be to appoint another director so they could then take formal action. So it doesn't matter how many actual directors are on the board. It depends on how many total seats there are, and then a majority of that to get to a quorum.
So everywhere is going to be different.
We need a break.
Okay, we're going to go to break, our last break of the day. We will be right back with more Ask the Experts.
The opinions expressed on the following sponsored program are strictly those of the host, guests, and callers, and not necessarily those of this station, its staff, management, or
360.
sponsors. Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
Hey, we are back. This is the Ask the Expert Show. I'm Steve O. I'm here with our first Thursday show of each month. Here from 5 to 6, we have the Kaye Rembaum. They have been with us the longest, and it's probably one of our most popular shows.
Except for today.
Yeah, but you know what? It's just, in the summertime, people just go away, you know?
Yeah.
And I think we have a call coming in, and I'll get to it. And then we want to get to your schedule before we leave.
Well, we can talk about those while we wait. On August 27th in Pompano Beach, we have an interesting class on elections, condominiums, homeowners associations, and cooperatives for 1 hour, 6:30 to 7:30, August 27th. There are some continuing legal education credits for that. Only one, but it's still some. And since we're coming into the election season, that's a good time to bone up on the various differences.
Right. You want to take a phone call?
Sure.
Let's go to Dale. Hi, Dale.
Hey, how are you guys doing this evening?
Doing good.
Good. I have a question. Our manager seems to be quitting as fast as they're being hired. Obviously, how good of a board we have. So what the board does in the interim, they have the admin doing the manager's work. I know you need to be licensed to do certain kind of activities like taking in payments and financial work. What about calling vendors and getting them to do work on the property as well?
Did you say whether or not you're a condominium or an HOA?
It's an HOA.
Okay. And you have no manager? That's the problem?
That's the problem. They're leaving in about a month after they're hired. But like I was saying, the board has the admin doing the manager's work in the interim of hiring managers.
And the admin is a paid employee?
Yes, she's a paid employee. She's not a board member. She just assists the manager when the manager is there. But like I said, in the interim, they have the admin doing all the manager's work.
Well, that if you qualify as a place that has to have a licensed manager do the tasks that you've identified, then to have a paid employee do that without having a license can subject the employee to potential problems through the Department of Business Regulation for not having a license and doing licensee work. And the association could also find itself subject to the same type of sanction, which could be a monetary fine for having an employee engaging in work that they need a licensed manager to do. If there's a concern about that, you would want to notify the board by certified mail of your concern that they're in violation of the law for that. And if they ignore you, then your recourse would be to make a report to the Department of Business and Professional Regulation of the unlicensed activity that's going on, and they'll make inquiry, and that could nip it in the bud.
Right. Would you consider the admin calling vendors and getting them to do the work on the property something that a manager should be doing and not the assistant?
It sounds like that's possibly not, but what you'll want to do is check in Chapter 468 of Florida statutes as it deals with community association managers, and there's a list of items that if they're doing that, they need to have a license.
Right. All right. Thank you, guys. Thank you very much.
All right,
Thanks,
Dale.
Dale.
Thanks for listening.
All right. Bye-bye.
Is that an unusual question?
These days it's less usual, but it does happen from time to time. When the licensing first came out, there was a host of things going on, but sometimes it's unavoidable because you haven't found the right manager and you're in between and you need to get things done. So if it's not an ongoing thing, it's just a temporary, that's a different issue than if the board is intentionally skirting it.
Why don't you finish what your schedule? Did you finish?
I didn't. I just talked about
Yeah.
Pompano Beach on August 27th at 6:30. We have 3 courses being offered in August in Palm Beach Gardens. Condominium board certification is on Wednesday, August 14th, 3 p.m. to 5:30 p.m. at our Palm Beach Gardens office. Then Wednesday, August 21st, will be the Homeowner Association board certification course, 3 o'clock to 5:30 p.m. And on August 28th, the 2019 legal update, 3 o'clock to 5:30 p.m. Space is limited in both places, more limited in Palm Beach Gardens, so it's a good idea to RSVP to both places to make sure that there will be a seat for you.
Because it does get filled up.
It does get filled up, and we want to make sure we have enough light snacks available for everybody so no one goes hungry. And it's good to know who's coming.
Someone told me the other day that these seminars, people just come for the food. But see, I know different, though. Because
our food's not that great.
Well, no, but I was at your seminar. People came with great questions. They were prepared. And then, after hearing everybody else talk, they had more questions. And we were there 2 hours.
Our Ask the Attorney traveling show is one that has no format. It has a format. It doesn't have an agenda. So whatever we talk about is going to depend on who's there. And whatever questions they have and bring to us, that's what we talk about.
People enjoyed that.
We found that to be better for everyone. We used to do, more of a structured agenda and lecturing, but that can be boring after a while. And the owners the people who came all had questions anyway. So
Yes.
The questions were happening. So why bother with the structure part when we can focus more on the questions?
There's we got a email from someone that lives at a marina condo, and seems like they're upset because the owners only have to have $10,000 in insurance, I guess, on their boat, but tenants have to have $300,000 insurance. And he wants to know, it doesn't seem very fair.
Well, fairness isn't always an issue that is important to look at as it is with under the law, because not all of the law is fair. But in this setting, unless it's in the covenants itself, an association is not allowed to treat tenants differently than owners on and the rules and policies that they establish. There is case law on this subject, and you can't create two classes of individuals within the community and treat them differently by rule. You can do it in the covenants, but you can't do it by rule. So you'd have to check the documents on this particular community to see if it's in the covenants, and if it is not, then there's a problem that the board is exposing itself to a potential claim of failure to properly deal with this issue.
You know, I always end the show this way. People out there, I know there's board members out there listening to the show, management companies. Why should I retain your firm?
Well, again, our experience in the field, our expertise, the fact that we have nearly half of our attorneys are board certified by the Florida Bar, which is a very high standard of education and background in the field, besides the fact that the 30 years plus of experience of the firm itself is translatable into more efficient, less expensive, and easily to understand type of a working arrangement with the association attorney. We're available and accessible.
Okay. I loved doing our show. Great job. It's a little bit more difficult when you're only here by yourself.
Not so difficult.
Okay. Anyway, everybody have a wonderful week this week. We'll be back next Thursday, 3 to 4 on 740 a.m. and 5 to 6 from 5 to 6 on 1470 a.m. Have a wonderful week. Thanks so much,
Good night,
Robert.
everybody. Michael Bender will be back with us next month.
Thanks for listening to the Ask the Expert Show, featuring interviews with local experts in the fields of legal, health, financial, and home improvement. Call our office at 888-574-6999 to become one of our experts on the show. And tune in again next week for more Ask the Experts with Steve-O.
The opinions expressed on the preceding sponsored program were strictly those of